Let the record reflect we're outside the presence of the jury. State has rested its case in chief. Defense.
Yes, Your Honor, and just, I know that everything was a little bit rushed, but as the court saw, there were several things that this witness testified to that he had spoken with the DAs about. 2 months later, I know the prosecution's position is that we had the recordings, but we basically were given documents that were misleading, that did not identify our client. Apparently there was other versions and other documents that were not provided, and there were conversations about his further analysis, about this witness's further analysis with the DA that were not given to us. They were not turned over. They were not told, hey, we had an interview with this guy and he's now identified the unknown that we've given you as Adrian Gonzales. I will say that identifying the voices in the recording, we have gone through those recordings with our client. It's not him. And so that's one of the reasons we're so upset about this, is because there are other people that we have identified as the person. So we're asking, I mean, again, this is another issue where they have been told things and had additional information by a witness, did not turn those things over to us. They are saying they turned over the recordings, but by turning something over that says we don't know who this is, and then by having the witness go and tell them, oh, I know who it is, it's Adrian Gonzales, and then not telling us that, it feels like a trial by ambush. It feels like they are setting up a straw man for us to go and defend against, and then they're switching the ball and they're moving it that way. So again, we just believe under Heath that the remedy would also be to exclude this witness, and we would ask the court to do that, because these are critical issues, and it goes all the way back to Randy Hill, and all of a sudden appearing that he knows that Randy Hill appeared at a certain time because he went back and looked on and that happened last week, and we finished the cross. I went back and I looked and I saw the lights and when he arrived, which is important about when he arrived because his timeline shows a difference of like 4 minutes, but now he's shortened the timeline. He says he told the DA about that 2 months ago, and it didn't, and nobody ever told us that. And so, well, all we have is some timeline, and they can talk about the dispatches all they want, but they cannot talk about the mental impressions of the ranger saying, I have now identified that Randy Hill is the person who arrived at this time, gave them that time, and they never told us. So those kind of things are important. As the court has seen, like we're going second by second with this, and these seconds that are off and these things that have not been included have put my client at a disadvantage, and his due process has been harmed by the failure to disclose.
Okay, State.
Your Honor, they said that they have the dispatch tape, they've had the ability to watch them. As Mr. LaHood said, we didn't know about that. We don't know about that. They have those tapes. We've given them the raw footage of that. And in addition to that, Your Honor, we've given them everything that we've had. They have told us they didn't even look at the portal. All they looked at was the original Ranger's file. So for them to even say that they don't have that information is, I think, not being candid with the court.
Was it on the portal?
Excuse me?
Was it on the portal?
Judge, thousands and thousands of pages. We have given them the dispatch. We've given them the times of the dispatch. We've given them all those things.
Well, this supplemental investigation that he keeps talking about, was that on the portal?
Yes.
All right.
We have provided everything Nick Hill has given us.
What I'm saying is that there's a conversation that was had with the prosecutors. They cannot show the court that they have provided us. We talked to Nick Hill, or we talked to Ranger Hill, and he told us that he has now been able to identify when Randy Hill was at that corner. We don't have that. That was a conversation between the witness and the prosecutors, and they didn't provide that. There's not an email that provides that. There's not anything that they can show the court that provides that. Additionally, this additional, whatever version of the report that he's talking about, we do not have that version. And he started by saying that he's got a different version up there because ours has page numbers and his doesn't. He has changed that, and I don't know whether he's provided it to the DA. He said he did, but he has changed that. I mean, the only thing, I mean, we have the information that we were sent about other witnesses, but none of them include anything about that kind of information.
So specifically in regard to Officer Hill and to identification of Adrian Gonzales on the transmissions, was that provided to the defense in the portal or otherwise?
I can say that Coronado originally told us that it was Adrian Gonzales, so that's the operation that we've been going under, Your Honor. As far as specifically that, you're asking me to go back over.
Yeah, those two fairly significant items, those two, I'm specifically asking about those two because they're significant.
I can't represent the court now. I have to go back and look at all that. I would need time to do that. I'm glad to.
Well, what is your request as I instruct him to disregard this officer's testimony under Heath? Is that what you're asking?
Yes, Your Honor.
Okay, I'm going to deny that. My suggestion is, for purposes of whatever happens on appellate remedies, et cetera, motions for new trial, I get on it and look for that. Okay, again, the state has rested. We're outside the presence of the jury. Did you have another matter you want to take up?
Yes, Your Honor. Do you have a copy of the amended, the second amended indictment?
I do. Well,
Okay.
I've seen it, but I don't have it.
Yes, Your Honor. Just to remind the court, I guess our first issue, it's all a legal sufficiency issue, and it's a legal sufficiency issue that's sounded in and based upon the idea of a duty. So, one of the things in the indictment is that the state has alleged that our client has a duty under Article 606, under Article 605, and under the Texas Education Code 37.081. The state has not produced any evidence of these statutes. We do not have any witness to testify about it. The jury cannot determine what the statute, how the statute would apply. If there is a duty, it's not even in front of it. It's not even in front of the jury. So they have not provided any evidence of these statutes and what their content is. Now, theoretically, the court's going to have to put those statutes in a jury charge, but that'll be the first time the jury's ever seen it. And so our first issue is that they have not established the duty about which they have put specifically in their indictment. They've not established, there's been no evidence at all throughout this trial, throughout the state's case, that discusses or talks about or even judicially notices these statutes. And so the jury will not be able to, based upon the state's case, will not be able to sufficiently apply the statutes to the law. That's our first issue. The second issue is that the indictment has witness one as the person who supposedly gave the information, then based on having that information from witness one, alleging that Adrian Gonzales failed to do these things. Throughout the entire case, witness one was not identified. And the reason that that's important is that there were probably 3 or 4 witnesses that gave Mr. Gonzales information. And the analysis and the jury's analysis would change based upon who that witness one is. Is it Coronado saying I think he's in the school? Is it the dispatcher talking about where they think it is, heading towards the school with a gun? Any of those things. So witness one, having not been identified in the state's case, would not allow the jury to, I guess, unanimously determine who witness one is, and did Adrian fail to do his duty, which is under statutes that they don't know about and have not heard about. Did he fail to do his duty based upon information given by witness one? It's not a matter of that they think, or that they can say, oh, well, we all know it's Melody Flores, or we all know that it's whatever. They have to provide some proof on that if they have witness one in the indictment. I know that there is some case law that deals with pseudonyms and pseudonym issues, but the problem with that is that with the pseudonym, that's usually in a sexual assault case, and it's usually there's not anybody else that was sexually assaulted. So it's pretty clear from the evidence. In this case, there are several people that give information to Mr. Gonzales at different times. And so, I mean, is witness one Donald Page, who's, as they're going down the hallway, saying, I think he's in that room right there. That's a general location being advised, but in that instance, they wouldn't say that he failed to go and distract him, because he did. And so the jury could find, if that was witness one, the jury could find that. So it's kind of basic proof that they have to provide, that the jury has to have. And then finally, we do have the case law, Luther versus Texas Parks and Wildlife, which states that, and it specifically talks about Section 606, and it states that the object of the code is not to impose new duties on government actors, the breach of which could give rise to, in this case, civil liability. Our argument is if it can't give rise to civil, it can't give rise to criminal. Rather, the code merely attempts to set forth guidelines for peace officers, sheriffs, and others to follow in the performance of their everyday responsibilities. So what this case is talking about is that these duties that the prosecution has alleged in the indictment, their intent is to tell officers what they can and cannot do. It's not to impose some sort of civil or criminal, really. I mean, it doesn't say that in this case. They're talking about a civil case. But the criminal aspect is I think everybody's heard, it's the first time in Texas anybody's tried to do this. So this is if you took what they said about the civil issues, if it can't give civil liability, then it for sure can't give criminal liability, which has so much more consequences to a person. So their duty, their theory of duty is flawed, but even so, they didn't present any evidence of their theory of duty. There's no evidence of what the statutes are and what they say, or whether there's a duty or whether that duty was breached. And then finally, they don't provide any evidence on witness one, which obviously, if it could be several different people, then it changes the analysis. So ultimately, our argument is that they have not proven and they have not provided evidence on every element that they have indicted beyond a reasonable doubt that a rational juror could find beyond a reasonable doubt. And so we're asking the court to grant a directed verdict.
All right, state's response?
Yes, Your Honor, as to duty, the case law is clear that duty is purely a matter for the judge to decide, and once the judge decides that, the judge then instructs the jury on duty. Duty is not a matter for the jury to decide, it's a matter for the court to decide. Many cases involving parents' duties, as far as children and child abuse cases, in which the court does not grant the state's request to introduce the case law to the jury, rather that their job is to give them what the law is based on the law. So it's not the jury's job to make that decision, it's the judge's job to make that determination based on whether or not there's proof that this officer is a police officer. The second issue as to witness number one, there's ample proof that there was only one witness that identified where the shooter was, and that is Melody Flores, and so the jury has ample evidence to find beyond a reasonable doubt that Melody Flores is witness number one.
All right, I'm going to overrule the motion for instructed verdict at this time. So you ready to proceed? You need time?
We need just a little bit of time, maybe 10, 15 minutes.
All right, he's our timekeeper. We're going to tell the jury they got 10 more minutes on their break, and tell me when 10 is up. But we'll be in recess for 10 minutes.